USCIS just announced a policy change for those who are applying for U.S. citizenship, also known as naturalization or Form N400. And I'm here to tell you all about it and what's the truth. Hi, I'm attorney Megan Pastrana of Immigration for Couples, and my firm is dedicated exclusively to helping couples across the nation and across the world in navigating the U.S. immigration process. I'd like to go through this policy with you. I'm going to pull it up here on the screen in just a moment. And I want to make sure that you walk away from today's video with education, with clarity, and the facts, because this administration is really big on creating fear. They want to create fear and confusion because that will result in paralysis and lack of action. Individuals are going to be so confused and so afraid that they are not going to want to file for naturalization. And the truth is, filing for naturalization is an honor, it's a benefit, and it's something that we really recommend here in Immigration for Couples that all of our clients complete. Of course, there are some situations where, if your country of origin doesn't allow for dual citizenship and things like that, I respect that there are reasons that sometimes individuals will decide to not become a citizen, but I don't want this policy update and this administration to be the reason that you're too afraid to move forward with securing your future. All right, so let's go through this policy here together. I'm going to pull it up here on the screen. So this policy memorandum was announced on August 15th of 2025. It's called Restoring a Rigorous, Holistic, and Comprehensive Good Moral Character Evaluation Standard for Aliens Applying for Naturalization. So it's a mouthful, right? This administration loves to repeat and reiterate what's already in the law and then memorialize all of that like it's new and novel, like they came up with it. But the reality is a lot of this is already what the law is currently. And then they're basically saying, this is a law, and now we're really going to follow it. We're really going to be strict now. So you have to take these policy memorandums with a grain of salt and then also educate yourself on what is the truth. So let's go forward, though, and let's focus on what's the most noteworthy piece of this policy memorandum. So it's here on this page of the policy memorandum that says greater emphasis on positive attributes or contributions. So it says that USCIS will now place a greater emphasis on an alien's positive attributes and contributions in good moral character determinations. And the factors include sustained community involvement and contributions in the U.S., family caregiving responsibilities and ties to the U.S., educational attainment, stable and lawful employment, length of lawful residence in the United States, and compliance with tax obligations and financial responsibilities in the U.S. All right, so that's the most noteworthy piece. This is what they're trying to, if you will, add to the good moral character determinations. And so if you're looking at this, it sounds logical, right? You would want that someone who is applying for the benefit of becoming a U.S. citizen to meet certain criteria. It's an honor, it's a benefit, it's a privilege to become a U.S. citizen. So yes, that's all well and good. But what this administration is trying to do is really add these criteria and make people what's happening, what I'm seeing is that a lot of individuals are concerned with applying for naturalization because they're concerned that now that this means that an immigration officer could say, you know what, I don't think you're involved enough in the community, or you know what, I don't think you have enough higher degrees, you haven't done enough studying at university, and I'm going to deny your application. And the reality is that immigration officers don't get to do that. This policy is not telling immigration officers that, if you don't think that the person meets these requirements or meets these criteria for good moral character with community involvement and family caregiving activities, etc., that you can just outright deny the application. That's not what this policy is allowing officers to do at all. Good moral character has existed for a long time. It's always been part of the naturalization requirements. And good moral character, it's a legal term of art. It is defined in case law as, and I'll read it exactly here so I can give you exactly what case law says. It says that it is the acts and conduct of an individual, and that the person's character measures up to the standards of average citizens of the community in which the individual resides. What is of good moral character within the meaning of the statute is not easy to determine in all cases. So The naturalization process and application process, what hasn't changed is that the eligibility requirements for naturalization are still the same. Good moral character has always been in there. Immigration, or through this policy memorandum, is saying these are additional characteristics or criteria, if you will, that should be taken into consideration for good moral character. But an officer doesn't get to just decide, no, I don't feel like approving your application today. And I'm actually going to pull up another piece of the policy, the USCIS adjudicators policy manual. And the policy manual says that where an application has discretion, so discretion is a place where the immigration officers need to look at all of the facts and make a decision about whether or not a person is a person of good moral character. Where there's this type of decision, the officer cannot exercise their discretion arbitrarily, inconsistently, or in reliance on biases or assumptions. So you can see this here, right here in the Chapter 9, rendering a decision of the policy manual. It's highlighted here for you, that means that when it says that they cannot exercise their discretion arbitrarily, that means that they can't just randomly say, you know what, I don't really like this application or this applicant, and I'm just going to deny it. So they can't do that. That's actually in the policy memo. So it's not like an application for a scholarship or to go to college or something where there's this discretionary component where they're looking at your extracurriculars and looking at your community involvement and deciding whether or not to accept you. U.S. citizenship is not that way. The officer doesn't get to use their discretion that way. The other piece to understand is that if an immigration officer decides that they do not want to approve your application, in other words, if an immigration officer denies your application, I'm going to pull up this piece as well here from Chapter 4, Results of the Naturalization Examination. If an officer denies a naturalization application, the officer must issue the applicant and his attorney a written denial no later than 120 days after the interview. And the written denial notice has to include a clear, concise statements of facts in support of that decision. They have to cite the specific eligibility requirements. So they have to cite the law specifically and say, this is the law, and this is why I'm denying this applicant, because they're not in alignment with the law. And the denial also has to give the applicant information on how he or she can request a hearing or a review of the denial. So there's formal mechanisms in place that if an immigration officer does decide to deny an applicant, that you can appeal that decision. You can even ask for a hearing. I've done that in the past for clients where immigration makes a mistake. They do. They make mistakes. Or if an officer is trying to inappropriately use their discretion, there are tools, there are steps, there are options for you to have your application fairly reviewed. It's not the end of the road. It's not, I don't like your community service. I don't like your educational history. I feel like denying your case today, not approving it. That they can't deny the case that way. They can't just give you a denial notice that says that, because that's not in compliance with the law. So yes, I recognize that there are constant changes and updates with this administration. It can be confusing, unnerving, overwhelming, stressful, scary, all the things, but I want you to be aware and educated and not fall into the fear and paralysis trap that this administration and these types of policy updates are trying to result in that impact for applicants to be too afraid to apply. I hope that this provided you with some clarity on the truth of the situation. If you have any comments, throw those in the comment section below. If you have other questions that you would like answered, I'm constantly making videos on this channel to give you information and updates. If you'd like to speak with me one-on-one about your case, you can contact our office. The phone number is below. And we also have a free resource center at immigrationforcouples.com. All right. Thanks so much for watching.